everyone, welcome to our first attorney Q&A featuring Justin Lurie, a seasoned corporate lawyer specializing in advising startups. With extensive experience in corporate matters, including venture capital financing and M&A transactions, Justin offers invaluable insights for entrepreneurs navigating the legal landscape. Justin is a New York State Bar Association member, admitted to practice law in New York and Florida. He also holds a JD from the University of Illinois at Chicago's John Marshall Law School and a Bachelor of Science from Indiana University's Kelley School of Business. Having worked at reputable firms such as Crowell and Moring, LLP, and Pearl Cohen, Justin's expertise and practical experience makes him an invaluable resource for startups seeking legal guidance. Join us as we explore his insights on startup legal strategies. So, Justin, over to you. What legal considerations are paramount for early stage startups seeking venture capital investments from corporate venture capital firms?
So thinking about corporate venture capital firms and what you need to think about when you're, or corporate venture capital arms, I should say, when you're thinking about taking investment from them is kind of understanding who they are versus maybe a traditional venture capital fund, in that they're not just money, they are strategic partners. With that being said, I think that you need to really think, are they strategic? How do they fit into your long-term plans? Are they a potential commercial partner? Can they assist in R&D in some kind of way? Are they potentially somebody where you could be an exit to? Do you benefit from having them in any of those areas? And there's probably some others that I'm not thinking about. Those are kind of different considerations than you would think about with a typical venture capital fund. And to the extent they don't kind of fit into your vision, you need to think about that. Perhaps they are a competitor and their check is not helpful to you in that sense. Or perhaps they view the developments of your technology entirely different than you do. In some ways, that might be good to have another opinion in there, another, more thoughts. The discourse is helpful, but in some ways that is maybe somebody you don't want in there. So you really do need to think about the long-term strategy and how they fit into that.
Thank you so much, Justin. So, what are the fundamental differences between receiving funding from traditional VC firms versus corporate VC firms, and how might these variances affect a startup's growth strategy?
There's significant differences in a sense that, on the one hand, they're both giving you money with kind of like these ideas of outsized returns, hopefully one day. But the big difference is what they want out of the relationship and what you want out of the relationship. A venture capital fund is not looking to buy you one day. They're not looking for a commercial relationship from you one day. There really is not much of a commercial element. This is an investment tool, and they are serving their limited partners. Strategic investors, corporate venture arms, are investing off their balance sheet. And I guess they also serve their stockholders in some way down the road. It's not quite as direct because it's a different wing of the company, if you will, that they're investing from. So with that being said, the things you might negotiate with a strategic are entirely different than what you might negotiate with a traditional venture fund. Strategics often have more robust side letters with commercial elements to it. A lot of things with eyes towards an M&A, maybe a right of first notice or a right of first offer, a right of first refusal on an M&A event, whereas a traditional venture capital fund does not care about things like that, typically.
Thank you so much for sharing that. Now, could you also outline the typical process and timeline for negotiating and finalizing a venture capital investment agreements with an investor?
So this, I would say, depends on the stage of the company. First of all, if you're a pre-seed company, maybe you need money out the gate, but let's just assume you're out the gates already, and maybe you've already raised the seed round, you want to raise the Series A. There used to be a rule of thumb. People used to say that you need to be going and looking for your funding, beginning your process with more than 12 months of runway. People who do it with 6 months, you're kind of too late, is what they would say, and then there's a chance you're going to run out of money in the process, and then you're at the mercy of your investors. So I think you start your process 18 months out, maybe 12 months out is probably realistic for most because they don't want to spend their time fundraising. You talk to funds, you have a pitch deck, etc. But to get to the legal side of this, eventually there is a term sheet that gets presented to you from the investor. It's not the other way around. Sometimes startups aren't aware of that. And on that, it's going to talk about, there's going to be some economic terms, which is price. What is the pre-money evaluation? What is the option pool going to look like? And we can talk about what that is, but that's kind of a block of equity put aside for future employees, future service providers. So those are like the economics. And there's a lot of technical terms in there, depending on how quickly everybody wants to get this done, how good the term sheet it looks, depending on how many term sheets come in. There could be competing term sheets, and we could be weighing a bunch of these things. The term sheet process could take a week, 2, 3 weeks, depending on certain items. And once you have the term sheet signed, then you go into documentation, the long form documents. Depending on the type of financing, well, for the sake of this conversation, we're going to assume it's an equity financing. There are other types of convertible security type financings that we can also talk about. But assuming it's an equity financing, there is 5 core financing documents that get negotiated in this process. So the charter, the stock purchase agreement, the investor rights agreement, a voting agreement, and a right of first refusal and co-sale agreement. I would say a typical timeline is 4 to 7 weeks that you can kind of anticipate lawyers taking the pen, first drafts to closing. There's also a plethora of ancillary documents that get drafted in the process of this that are, board approvals, stockholder approvals, things of that nature. And with later stage deals, perhaps current investors have blocking rights and maybe they're less likely to just sign off on the document and they might have their say and that could lengthen the process. And obviously the more cooks you have in the kitchen, the more people that kind of have a say could extend the process.
Thank you so much for sharing that. Now, how can startups safeguard their intellectual property rights during discussions with corporate VC firms, particularly regarding potential collaboration or technology transfer?
So this is like a very fair question and a real concern amongst corporate venture capital arms and amongst strategics. Amongst institutional venture capital funds, maybe it's less of a concern. I know you're not necessarily concerned about them stealing your tech, building something, or stealing your tech and giving it to somebody else. If they were to do that from a practical matter, their reputation would be that, and they would not get into deals anymore, and they wouldn't be able to make any money. But that being said, a traditional venture capital fund is much less likely to sign an NDA in the process. But with strategics, I think they understand it, and they're much more likely to sign an NDA or some form of confidentiality agreement. You can also withhold what you share with them until you're further along in the process. That's always an option. You can redact things. That's an option. With a strategic, an NDA is a pretty good way to do it. And then once you get towards the documents, there are other safeguards that come into play. Like once they become an investor, we can talk about that as well.
Thank you so much for sharing that. Now, what key aspects should startups focus on when structuring equity ownership and governance to accommodate corporate VC investors while maintaining founder control and vision?
I think like a lot of this is stage dependent. So the earlier on you are, founders want to and should try to maintain control of their board, hopefully through their Series A. This allows them to keep the company in their vision, if you will. But some other things that come up in these financing rounds are blocking rights, veto rights, protective provisions. And this is especially with early stage companies, investors say, they're young, maybe they don't know what they're doing. Like there needs to be like an adult in the room to check them on certain things. So these are probably like the most negotiated points of the term sheet stage. And it also bleeds over into the long form documents and what they get to block. So things like an M&A event or a new round of financing or increasing the board size, things of that nature, they're typically going to want to block on those type of things. So those are things you negotiate. There's different ways to push back on that. Maybe they don't get a say on all M&A, but only M&A if it's only for a small return or things of that nature. So there's balances that you work through on those, but probably early stage, keeping control of the board is pretty important. And I think giving that up early could lend itself to a kind of a lost vision of the founders if things go sideways or whatnot. But we also typically don't see them lose control of the board that early either. We want to keep it at a 3 or a 5-person board. Maybe an independent person joins and whatnot, but certainly more rare for it to be, we'll have 3 investors and 1 founder on the board like that, or whatever. That's more the exception, not the rule.
Thank you so much, Justin. What are the primary concerns or negotiation points startups should pay close attention to when reviewing term sheets or investment agreements from corporate VC investors?
So I don't know that it comes up as much in the term sheet, but in the long form, or just generally speaking, I guess, information sharing is the biggest concern with corporate venture capitalists. So to the extent they want to serve on the board, which some of them don't want to, they're not even allowed to take on the fiduciary duty of being a board member, but maybe they want to be a board observer, so they're invited to all board meetings. Or maybe they have certain information rights that they need or they want or whatever, and you agree to that. Paying very close attention to what you're giving them when you have the ability to pull back and say, look, like we're deeming this a conflict of interest, or this creates a competitive disadvantage. Things of that nature are when you want to be able to block that out. And we have language that we often often craft that like, hey, we're going to share all this information to the extent we don't deem it a conflict of interest or it doesn't create competitive disadvantage for us, or we don't deem you to be a competitor. That's another big one. If they are a competitor, maybe we don't want to share things with them. And the language of that is something that gets negotiated pretty heavily. Less so with traditional institutional venture capital funds, because you're not worried about the same things with them. You're not worried about them stealing your product, stealing your idea, creating it over again, etc.
Thank you so much for sharing that. Now, can you provide examples of successful collaborations or exits between startups and corporate VC investors you have been involved with, and what lessons can be gleaned from those experiences?
I can't I'm not going to share specific names of companies or whatnot, but I can say that as of recently, in AI, we've seen a few corporate venture arms end up purchasing the company, and I think that was a success for everybody. So I think that's great, and I think that goes back to strategy. Were they part of the long-term strategy? And I think in a few instances I've seen, I think they probably were. That would be one of the answers. Another one is like in a lot of these, what we see, commercial agreements come into place, and I think everybody wins from that. Oftentimes, where the strategic can be employ or engage the company in a commercial relationship, and it could be paid one way or it could be paid the other way, but it's profitable, and they can see how this works, and they can see how they can scale things. So we see that quite a bit in the context of these deals.
Thank you so much for sharing that. Now, how do you advise startups to prepare for potential conflicts of interest or diverging interest between the corporate investor and other stakeholders, and what mitigation strategies can be implemented?
Yeah. So this is similar to what we were talking about earlier, which is information sharing. Are you going to do with them? So a traditional investor, let's just say I gave you a very small amount of the company, 1%. You have like certain statutory information rights that can be waived, but not much. I'm probably not going to give you that much important information. I'm certainly not going to give you anything that is highly confidential. But perhaps you're a bigger investor, and you've negotiated for information rights. The first thing I would do is I would suggest keeping the tent small. If you're dealing with like highly confidential information in a highly competitive space, whatever, you don't want a lot of people being able to do this. So you have to be thoughtful. Like oftentimes founders need the money, and the ideas of money, they get a little bit blinded by that. Like, we'll figure it out. They don't want to take our information, and then they do. So I think you need to be mindful about that. Is like, this check is not really that important to this potentially this big, huge corporate venture arm. There might not be there for the investment, they might be there to learn. So keeping your tent small, and then when you're documenting, let's just say we are letting them in the room, we are going to allow them to be a board observer, making sure that contractually you have carve-outs from sharing information where it's highly confidential, it's a trade secret, it would be competitively harmful to you. Things of that nature, you need that in there. And so that language is really important, and that language gets negotiated quite a bit.
Thank you so much for sharing that. Now, are there specific legal or regulatory compliance obligations startups should know when engaging with corporate VC investors, particularly in heavily regulated industries?
I guess it just depends on the industry there. Health tech, there are certain things to worry about. If you're in gov tech, there are certain things you need to worry about. We could be here for a long time about that. But I do think there's a few things that everybody should be their antennas up about, which is when you're taking foreign investment. So CFIUS is a governmental agency that monitors investments in the United States, specifically from certain countries. Think of China, Russia. If you're developing certain types of technology, then perhaps it requires a filing from CFIUS, and that can be expensive and timely. So to the extent that you're bringing in foreign investment, I think like you should be engaging counsel and really thinking about that, and it's super important. Now, as of January 1st, there's something called the Corporate Transparency Act, which is now requiring us to kind of a governmental filing, and this is not public, but a governmental filing of certain owners of the company. This is new, and this is going to require us to collect more information about investors, which we hadn't had to do before. I will say a district court in Alabama kind of just struck this down. So there is more to be decided about this, but this is as of January 1, 2024. So we're all kind of learning about this as it goes.
Thank you so much, Justin. Now, how do you stay updated on emerging trends and best practices in early stage venture capital financing, and how can startups benefit from your expertise in navigating these dynamics?
So they can benefit by calling me. We could just talk about it. But how do I stay up on trends? I read a lot. I start every single day reading, like I kind of have like, aggregators, like a lot of people sending me things that are of important interest. Like I just brought up the Corporate Transparency Act. There was recently another court decision that will be impactful about protective provisions and what that means and if they're acceptable or not based on the documentation. So I try to read every single morning to make sure I am staying on top of it. And, as for how can startups benefit from my expertise, like I said, reach out, call me, if you want to talk about it. If you're starting a company, I would say a lot of founders may be sometimes penny wise and pound foolish, as they say. They don't have the money to, what they think they don't have the money to pay for legal counsel. And I would say often they can't, legal counsel can be flexible with you. But also the costs of not doing it correctly and trying to fix it and clean it up can be huge, can be much bigger than the few bucks you're saving. Not a few bucks, I'm not saying we're cheap, but the dollars you're saving early on, it can be much more penal than that when you get to a financing and your investor is doing diligence and maybe they find out that the company doesn't really own any of the IP because none of the employees have assigned it to the company. That's typically like a big issue that comes up. That I think that founders should try to seek out counsel early and early as possible, because I think that trying to cut corners and save bucks early on can be extremely costly later on in terms of trying to fix these issues, and it can be very, very penal. So I think they would really benefit. I mean, maybe they just learn about what the risk is so they know it. Oftentimes they're like, I can't even engage with a lawyer because it's too expensive, and they don't even, they think that, but they don't know what the risk is. The risk could be way more expensive than the cost of a few hours with an attorney. Or trusted advisor. Maybe it's not an attorney, maybe it's your accountant, whatever the case may be. I think there's we just see it too often, both as an investor counsel or as company counsel, where the cleanup is like, okay, this is a big deal, and we're all we all have an issue from this. So that would be some advice in that regard.
Thank you so much, Justin, for your time. I'll be sure to add. So, how would you like them to connect with you? I'll be sure to add that in the description.
Yeah, we can put my email address on there, and you can reach out via email. And to the extent that it would be helpful to chat, that would be great.
Yeah. Thank you so much for your time. I hope you enjoyed this conversation as well.
I did very much. Thanks for having me.